guys. So my name's Lucy Garrett. I'm at a chambers called Keating Chambers, and I specialise in commercial law, which is not a thing that actually exists per se. I know you're all here to hear the commercial law talk, but really what we all do is specialise in particular commercial areas of industry, and we do law related to that area of industry. And mine is construction, which essentially is building projects that go wrong. Of any kind, ranging from when you're quite junior to someone's house extension, right up to oil rigs or ports or power stations or hospitals. And I've been doing that for 15 years now, which I can't really believe. It feels like about 2 years. I still feel absolutely terrified every day. And why I chose that area of practice is on this list for the question I'm supposed to answer. It sort of chose me. I was lucky enough to do pupilage in a more general set, and you guys would all know that it's quite hard to, you can't really pick and choose your pupilage, you just take the one that you're offered. But my pupilage chambers, where I was taken on, did a range of different areas of law, common law and commercial. So I got to do construction law as a pupil and loved it. It's really good fun. It's got a super combination of black letter, serious contract law and really interesting technical points in the underlying projects. Plus the clients are absolutely lovely. Really good fun. Contractors are great. And so I moved to a specialist construction set after a couple of years, and I've been there ever since. So I'll hand over to Ashley.
Hi, my name's Ashley Cukier. I'm at Littleton Chambers. I was called to the bar in 2013, so I'm still junior, one of the juniors, as we're called in chambers.
Baby junior.
Baby junior, okay.
Yeah.
Maybe in your chambers they're called baby junior.
Baby.
I've advanced to junior.
They're baby juniors in our chambers.
Okay, so there you
Maximum
go. The differences between the chambers are coming out already. I do a mixture of general commercial litigation, civil fraud and insolvency. As Lucy said, it's a real mix, and different commercial, in inverted commas, juniors and chambers will do other stuff. The work is very varied. You're going to be dealing with interesting clients and interesting solicitors on interesting pieces of work that involve, as Lucy has mentioned, a combination of getting to understand some difficult and complex facts, but also getting into the nitty-gritty of understanding how contracts work and how they operate and their implications. We'll talk more about it in due course, but I liked the idea of going into a career that was commercial law rather than other areas of law, because I liked at law school contract lectures and seminars and really getting into the language of documents and trying to work out how you can argue two different points of view on essentially the same piece of text. And that's what interested me at the time and still interests me now. So we'll talk more about it, but that's a sort of very, very brief overview of the sort of work that I do at the junior end at Littleton.
Hi all, I'm Simon Pritchard. I practice from Blackstone Chambers. I was called, sometimes asked this in court, you have this annoying document called a cost schedule at the end of court, which has all the costs of your side and often has your year recorded. I think I'm 2007, which is particularly scary because, like I think all of us, when I appear in court, it still feels like my first day. And there is always that scary moment when the judge comes in, which I still experience and I expect I'll experience to the end of my career. But I have actually been practicing for, 8-9 years. I practice in commercial law, but I also do other areas of law. At Blackstone Chambers, we have quite a broad base of areas that we cover. On the commercial side, and where I really specialise in, is financial services regulation. It is a really interesting area of law, especially because I did a secondment at the FSA, as it was then, in 2008, the week after Lehman Brothers crashed. So I was able to learn so much from being at the regulator, and then that is what I have transferred into my practice as a financial services practitioner. Now, it's not really one of those areas of law that you study when you're at university. So what does it entail? Well, you will have heard very numerous press articles about naughty traders, naughty bankers who go through prosecutions by the regulator. So I may find myself involved in those types of cases, defending or prosecuting these naughty barristers. But then on the other side, I may find myself advising the banks on what their regulatory standards are, what their sales procedures are. We all know about PPI calls. I had involvement in the PPI debacle. That would have been back in 2010, and now we all have phone calls every day of the week saying, have you heard about PPI claims? So that kind of field is financial services. On top of that, I do more general commercial work as well. And not construction, but I may do, for example, a software dispute where one party has developed a piece of software. It does not do any of the things that they promised it would do at the outset. You then have a long drawn-out dispute over what were the terms of the contract. Those types of disputes are interesting because the contract is always very vague as to what exactly the parties are agreeing to do. Often the parties have gone into their dealings with each other without really setting down in stone what their expectations of each other are. So then we end up in long litigation where you're discussing those types of issues. As well as that, I do media law as well. And media law, again, is not an area of law that you think about at law school, but that is an area of law that involves commercial law. So I may be thinking about film finance disputes that arise, or even acting in cases involving X Factor and Britain's Got Talent. There's contract disputes and commercial disputes that even arise in that field. So although commercial does sound like it's a very narrow base, actually it covers a great broad of different cases. Now I think having almost covered the second bullet point, I think the second bullet point in our talk is what types of cases barristers in this area deal with, and I think you were going to address that.
I mean, obviously chip in, guys, at any point, but the I think you probably tell from that introduction from what we all do that we're all commercial barristers, but our practice areas are very, very different. And the underlying common theme is that we all argue about contracts of different kinds, and all commercial law really is contracts in a commercial industry or arena. And it could be media, it could be financial services, it could be anything at all. That the whole of commercial life in the world is governed by contract law, and nothing would happen. Your food wouldn't arrive in Tesco's, and your electricity wouldn't come on if you turn on the light switch without contracts. And that makes the idea of talking about commercial law per se just impossible. But you can make a kind of rough distinction between what chambers in a broad sense tend to specialise in, and there are sort of three main areas. There's banking and financial type transactions as an industry, and that's a very broad description. There is insurance as an industry, and again that's broad too because it covers everything from disputes between reinsurers and insurers to disputes about whether an underlying risk is covered, and that could be a shipping case, or it could be a sale of goods case, could be all kinds of different things. And then construction is the other sort of major industry in the country. It's a huge 9 or 10 billion pound industry in this country. And there are lots and lots and lots of projects that all go wrong, and then lots of work for me. But the type of case tends to be, I mean, I'm sure you all know from looking on the internet and reading the handbooks and so on, that the more commercial the work you do, the less often you're in court. But you have to set against that the fact that when you are in court, it tends to be a heavy application. If it's an interlocutory application, it will be a day or sometimes even 2 or 3 days. If it's a final hearing, it's likely to be at least a week. And I routinely do cases that last several months. The actual trial, the final hearing, lasts several months. So if I am in court or in an international arbitration final hearing, then it tends to be a large proportion of my year in court, just on one case. And I'm sure that's the same for you guys. Then the other sort of feature of the advocacy is that you tend to be in the High Court because the cases are worth a lot of money. So from a very junior level, you're appearing in front of High Court judges, arguing quite complex technical black letter law type points. It's very, very, very intellectually challenging, hence the fear factor when you stand up for the first time that day. And it's very, very interesting. You will never be bored because every contract is different, and just when you think you've got some area pat, then some inventive clients will have entered into some other different version of that contract, a mad version, and generated a whole new argument to have.
I should say also there are the contracts that form the basis of the disputes that have been talked about, but then there are also the disputes that are offshoots from the contract. So, for example, at the moment, I'm working on a fraud case where there was an underlying contract between two parties, but we've now discovered, we think, that the money that we paid under that contract has actually been diverted elsewhere. So you've got to understand the underlying contract that you have, but then you've also got to start thinking about the offshoot, which is how do we get the money back, or at least how do we freeze this money until we're able to get to the trial of the dispute about what happened under that contract. And so we're talking about here freezing injunctions, search orders, disclosure orders. It can be quite fast-paced, and this is the kind of interlocutory interim stuff that was being talked about before. So it's not as boring as one might think initially if you're just thinking about barristers sat in a room with piles of books and piles of papers looking at contracts. There's actually real-life events that are taking place around the contract which involve you getting to court, perhaps on an urgent basis, and it's certainly not as boring or as
yeah, that's a really good point. I think. I mean, you can see it as quite dry, but it isn't really dry, because what drives a commercial barrister's success in their practice is their ability to achieve the commercial aims of their client. So it's no good advising your client that in 2 years' time, when we get to the final hearing, there's this Supreme Court case that will probably mean they win if they need the cash by Christmas. You've got to find a way of making the law and the contract. Or if
the cash is going to disappear.
If the cash is going to disappear, that's right. You're going to be issuing your freezer and going to court literally the following day. And anyone that does freezing injunctions and that kind of thing has worked over the weekend to go off and do an emergency application in front of a High Court judge on a Sunday.
Yeah. Well, we had a search order once, right when I just after I got tenancy, and I think we got the searcher on a Friday. We had 3 hearings during the weekend because the person that we're meant to be searching their house was certainly not playing ball with us, and we kept having to go in front of the judge. We had to find out where the judge was. You had to have a telephone hearing. We had to vary the order to allow us to serve it on her by throwing it in her face rather than actually hand it to her. Those kind of things. So you had to be really practical and think, well, practically, how can we get the outcome for the client? The client needed to get into the property to search the property. How can we achieve that? What kind of assistance do we need to get from the court to do that? And I think it's a really good point you make about being a commercial lawyer is not just about being a lawyer. It's about commercially advising businesses, because although our businesses, I'm sure, really love the law, they ultimately want to make money and want to be able to continue doing business. And you have to have that in mind. And that's certainly what I find most appealing about commercial law, is you have this interface between the hard law that we all occasionally argue in the Supreme Court and find very interesting, but also advising businesses on a day-to-day basis as to what they need to do to comply with the law, but also what they need to do to better their their interests as a business.
Do you want to do the next one, Sam?
Yes. Okay. So, what you find appealing about the area of practice? I've already covered this a bit. My background's a slightly strange, odd. Some could say. I did a chemistry degree, a chemistry master's, and
That's
then.
very odd.
Exactly, very odd. Then transferred into law. So I always had a slightly technical mind, and that is why I really enjoy my financial services work, because I justify it to myself saying I'm using my maths abilities, but I'm not. But certainly you are seeing patterns in commercial law, which is, I find, quite similar to the kind of things I was doing at university, and it's what excites me mentally. The other thing I find really appealing about this area of practice is when you come to trial, you often will have expert witnesses who you have to cross-examine, and they will be the best in their field. And cross-examination, although when you go to law school and bar school you're told it's not getting into an argument, but essentially it is getting into an argument with somebody, you need to know everything that person, that expert witness, knows about their field. And what I love about our job is that I will come out of a case and I will have learned so much about that one single area. Now, within 2 weeks, I'll have completely forgotten that and I'll be learning about a new case. But I just find there's something really academically fascinating about getting a real insight into that niche area of industry before one moves on and carries on.
That's very, very true. I totally agree with that. I think the hallmark of commercial law is that you're a specialist lawyer, but you're a specialist in the industry that you're doing the law about. and so you do get to learn. There's loads of expert work in my sort of area as well, and you become essentially an engineer about that small thing. And I did English literature as my undergraduate degree, which was a much better choice than chemistry. It's much easier, but I see my English lit skills in barrister work, because if you're trying to work out what a poem means, it's quite similar to working out what a contract means, except the contracts are not beautiful and inherently worthwhile, like poetry is. And
read over and over.
You're also better paid for doing the bit with the contract than you are with the poem. But it's definitely the case that being able to have a sort of underlying industry that you learn about a different aspect of it in every different case, and it takes about a day, in my experience, to sit down with an expert in whatever the field is, and then you ask a lot of stupid questions and they draw diagrams, and at the end of it, by the end of the day, you can say, well, hang on a minute, you said that a minute ago, but if that's right, then that, and then they look at you and go, oh yeah, and you're like,
it's amazing.
And
it's really satisfactory.
The other thing to pick up from what's been said is that it's quite interesting, by the sounds of it, none of us did a law degree for undergrad, because I did modern languages at university. And I think one of the other appealing aspects of commercial law is that because it's perhaps more paper heavy than some other areas of law that you may have heard about today or will hear about today, it involves lots of particularly written advocacy, being able to tease out arguments and put down a persuasive argument on paper. And for me, what appealed about the commercial bar is that it was able to pick up from the things that I liked about my degree, which was writing about literature essentially, and then putting down an argument in a persuasive way, taking a view and then really going for it and trying to persuade. And there are similarities between what I was doing at university about medieval Italian literature, for example, and the sort of the perhaps less glamorous contractual stuff that I'm doing now, because you're still having to put down your argument on paper and persuade the judge especially, but also the other side to perhaps not take a point that they thought was good if yours is more overwhelming. Being able to persuade through written and oral advocacy, it's something which you're going to be having to do at the commercial bar day in, day out, and I really enjoy that.
One last thing for me on the expert's point. Certainly in my field of financial services, it's amazing how so many industries protect themselves by coming up with acronyms for absolutely everything, and you often find that once you've broken through those acronyms, things just make logical sense. So I, as a barrister approaching a new expert, a new area of field, the first thing I'm trying to do is understand, to get below what the expert is telling me, just to really cut the acronyms that they're using. I was going to use a rude word, but I'm not going to. But and then once you understand the logic of it, that's when I find it really fun and fascinating just to learn about these areas of field. I think I was then going to do the next bullet point, which is the lifestyle implications. I mentioned to my family this morning that I was giving this talk, and I said to them that it's kind of sad for you guys, because how I respond to this question, the lifestyle implications, really turns on what last week at work was like. Because every week at work is completely different, I find. We're self-employed. Our clients are probably the most important people in our lives, and we have to service them. So if the client requires something to be done by a certain time, of course you can whinge to your clerk saying, I was meant to be going to the theatre, I was meant to be meeting friends. But there comes a point when, as a professional with clients who are paying you a lot of money to get a service, you have to put them first. So my friends hate the lifestyle choices I make, because they've pretty much given up on trying to meet me during the week, because you just do not know. There may be days when you're quite lucky and a case settles early and you can leave work quite happily at 12 noon and go shopping or go to the gym and have a good time. But equally, there may be days when things explode at work and you need to be there for a long time. So this week gone, I didn't leave Chambers past midnight for 2 nights. I was just working there all night. But that's because I had specific points that I needed to have got done. I wanted to get done so as not to invade on my weekend, etc. That's not usual, but it's also not entirely unusual. And I certainly think that anyone going into the bar needs to recognise that it does impact on your work-life balance. There may be other areas of law where you can keep yourself a better work-life balance, and certainly there's other people in Chambers who keep a better work-life balance than I do. But it does impact on your choices. but academically it's fascinating, intellectually it's wonderful, and it does pay well. So there are certainly benefits. Now, hopefully you two will disagree as to lifestyle choices.
Well, I was supposed to have been on holiday 2 weeks ago. I went away for a week and worked every day of my holiday, so I can't entirely disagree. But what I should say is that it's, as Simon mentioned, it's not always like that, and you need to be able to learn to make the most of the opportunities when they arise to enjoy what is supposed to be the perks of self-employment. So, for example, my wife is a teacher, so I know I can only go on holiday during school holidays. So I'll make sure that I've got holidays booked, in advance. I haven't got to ask anybody about taking 5 of my 25 days allocated annual holiday. I'll book it, and I'll book it in the hope that it actually comes off. But you do have flexibility about what you do if you're prepared at the same time to put in the hours when you need to, even at the expense of the stuff you might want to be doing during the week especially.
I think being self-employed as well, it has benefits, but for me one of the negatives is I always worried, maybe I won't get another job. So all the clerks have to do when they pick up the phone and they just say, Simon, we've got an interesting new case, and that's me sold. And I'm always like, yes, I'll do it. I won't go home. It's fine. I'll stay here all night. The hardest thing is learning to say no. And certainly at the beginning of my practice, I was dreadful at saying no. And indeed, it was a laugh within chambers that I'd just say yes to anything. But slowly you learn that there are plenty of cases out there. You can say no, and it's important to have a work-life balance. So I think I've got better over time. And certainly you look at QCs in chambers, they're not here for 2-3 months of the year. They go off to their houses in Italy, France, certainly my chambers, I don't know about other chambers. So
I do that too. I haven't got a house anymore, but my version of a work-life balance is to work all the time when I'm working, but I try and have 3 months off a year. Yeah. And that is being self-employed at its absolute best.
What other job allows you to just take 3
amazing.
months?
I did the same thing as you when I was very junior. I just took on, and I was terrified that every case will be your last case, and there was no security, no sick pay, nothing like that. So you're frightened and you want to establish a reputation, but then you get very tired and you realise actually it's not going to be a sort of sustainable project for the next 15-20 years. And so since I was about sort of 4 or 5 years cool, I've had 5 weeks off every summer. And as I get more senior, my holidays get longer. And subject obviously to, as you say, something coming in or just having to finish something off or a current, usually it's a current case going live unexpectedly when you've already got a full diary from other things. But I think you can, I think while you're working, it is very difficult to have a life. I'm going to work after this, and I've got an actual meeting tomorrow with clients, so that's good. Lovely Sunday. You have to resign yourself if you're going to do commercial law to it being long hours and hard work. And we can do this in questions when we finish up. But I'm quite often asked by, in particular, women, although I think it ought to be a question asked by both men and women. What about children? And the answer is it's quite hard, quite difficult to manage the two things.
But there's someone, I don't want to name names in my chambers, but like there's 2 individual ladies who I think they've got 3 or 4 children. They pick them up from school and they have amazing practices.
Yeah, no, well, there's silks in my chambers with children. It can be done.
It certainly can be done.
It is hard, that's what I'm saying. It's a challenge. Yeah,
and they inspire me because I am certainly sat at work until the hours I've been saying. Just sat there thinking, if I had children, I don't know how I would cope. But they are picking their children up from school, dropping them off. Yes.
This probably links into the final question that we'll answer from here before taking questions from you guys about the key skills and personal qualities. Well, I mean, that you need to succeed at the bar, to finish the question. You've heard already that you need to have a work ethic that is second to none. I think you can be as clever or even more than clever, you can be a genius. But if you haven't got the work ethic to match it, then I think you'll struggle to perhaps not win work initially, but certainly to forge a reputation at the bar in the way that you might want. You also need to be a good people person at the commercial bar, as well as being someone who's able to do the work, because you're not only working on your own. As much as we talk about self-employment, you're generally working as part of a team, in the sense that you might be working, as I often do, with more senior members of chambers on a bigger case. You need to be able to interact well with your solicitors who instruct you, because if you don't, they're not going to instruct you again. You need to be able to interact with your clients, who you might meet on Sundays, and get them on the right side as well. So you need to have that. And perhaps the third quality that I would mention, I'm sure you two might want to add, is you need to be able to deal well with pressure. I don't think anything could have prepared me for the first couple of years of practice and being asked immediately in a new profession, which you've not got any experience of, to start making decisions, tactical decisions in litigation about businesses whose success or failure might be contingent upon the decisions you make in this case. And if you think about it for a second, it's mad that someone, 24, 25 could be asked these questions by directors of companies who have been directors for 30 years of, multi-million-pound companies, and you get an instruction that's going to determine a decision they make, and the implications are vast, and you're being asked to make a decision in, 20 minutes, half an hour before tomorrow. I mean, are we going to issue this claim? Are we going to make this application? And you're thinking, well, I wasn't told about this at bar school or law school, and you just got to make the most of it. And you've got to be able to deal with that pressure, because it's both the pressure of court, which I think is never going to leave us, but also the pressure of being able to advise quickly and correctly people that are probably better qualified than you are to talk about their profession and their business. So you need to be a good pressure person, and if you're not, then it would be hard. And I think you need to have that kind of cool about you to be able to do the work, advise well, and still be someone who people want to work with at the end of the day.
It's being the person willing to take responsibility.
Yes.
You're at the top of the pyramid, and you have to be. You have all the power and all the responsibility. It's absolutely fine if you like bossing people about.
I think it's more than you said willing. As you said, bossing people about. You've got to want to and enjoy it.
Yeah.
And we are part of a team. And I think of 20, 30 years time, the bar was slightly different, and you didn't necessarily work as much as part of teams as we do now. So we are part of teams, but we are blimmin' important cogs in that team, and we do make decisions that people listen to. And certainly with my regulatory work, or if I work with public bodies in public law, you often find there's lots of people there who just aren't willing to make decisions. They've had all the right thoughts, but they're not willing to put their head above the parapet and say, this is what I think the answer is. And that's one of the things that drove me to the bar, is because I wanted to be the one who people turn to say, Simon, what is your opinion on this? What is your advice? And I like giving people my advice and saying, this is how I think you should do it.
And being paid for it.
And being paid for it.
Paid to tell everyone what to do. It's marvellous.
I think another personal quality that I didn't necessarily realise when I was applying, or even in my first few years of being a barrister, is having a thick skin. And I don't have the thickest of skins. But you find that there are some days you come out of court and you have had a horrible time, and it's 99.9%, if always, not your fault. You're arguing your client's case, you're arguing the points that your client needs you to make, you're doing the best job you can, but there are some days that you will have a horrid time in court, and judges will have a complete go at you, maybe because they've had a bad morning. So there are days that you come back to chambers and you think, why do I put myself through this? And you have to be able to just pick yourself up from those thoughts and move on and take your other case, because your next client who you're advising doesn't want to know that you've been worrying about what happened to you in court that morning. There are different mechanisms one can deal with it. Certainly we have a process in chambers where you share rooms with people about the same year call as you, which I found great, because it meant you could come out of court and say, you never guess what, this happened to me today. And then hopefully your friend will say, well, don't worry, last week this happened to me, that was even worse. And a bit of schadenfreude always solves the day. But a thick skin, I personally have found to be an important quality, which I don't necessarily have as thick as I'd like to have, but slowly it is growing.
Perhaps we should, I don't know how much time we've got left, but...
We've got about 7 minutes, so good timing. Right, can I ask for the first question, please? Who's got a good question? Over here.
Have you done many pupilages before? And your chambers are offering mini pupilages?
Minis?
Mini pupilages.
Before your pupilage, have you done mini pupilages?
Almost all commercial chambers offer mini pupilages.
And they were not all in commercial?
They will be in the area that the chambers specialises in.
But did you three do?
Oh, did I?
Yeah.
Yeah. No. I did. I didn't know what I wanted to do. I knew almost nothing about the bar when I applied, including that you're self-employed. Didn't even know that. So I did some minis in different areas to check. And that was very, very useful because I was able to eliminate some areas immediately. When I was thinking about coming to bar, I thought I wanted to sort of save the world and act for oppressed people. And when I started doing law, I realised that has enormous worth and human interest, but intellectually it's very boring. And I realised that I wanted to do intellectually interesting law.
And we can do that pro bono.
Yeah. You can be a good person
Good
in your spare time.
In your spare
So
time,
much.
the spare time you don't have.
But
You can kind of build human points.
But I'm afraid it's kind of true that intellectual interest is in the amoral stuff.
But the other point to make is that in terms of the sort of the practical side of making applications for barristers' chambers will expect you to have done mini pupilages when you apply, and it makes sense to, if you're not sure what area of law you want to do, to apply to different chambers that do different areas of law and get a feel for what they do, because
It's very different in practice than in academically.
absolutely, and you're only going to get so much from a chamber's website. You need ideally to be going into chambers and understanding how they work and the vibes that they give off in chambers and the sort of work that they do, because that's going to inform your applications to barristers' chambers down the line.
I took a two-phase approach. My first phase was learning what areas of law I wanted to do. So I did a common law set, I did a family law set, criminal set, quickly learned that's not what I wanted to do. That was phase one. Phase two was what we called All Pass, no doubt it's changed its acronym because that's what one does. But you then have the application process, and I decided I wanted to at least apply to every single set who I was applying for a pupilage at. I wanted also to have applied for mini pupilage. It took a hell of a lot of time, but I knew, and as I'm sure is the case, that sets will be looking to see, well, have they shown interest in us? Have they done a mini pupilage with us? So I think I applied for 10 sets, and I applied for 10 mini pupilages. Some of them were totally pointless. I had one horror story where I sat in the reception for the whole day, and the clerk, bless him, just kept coming in saying, "Oh, the barrister will be down in a minute. They'll be down in a minute," and they just never came down. Now I cannot, being now on the other side of the fence, I can kind of understand that sometimes when you have a client who is demanding things of you, being told you've got a mini pupil in reception is not the highest of priorities. So I can understand why it happened, but I had paid to come. I was doing law school in Oxford Brookes at the time, so I paid to come to London, especially for this mini pupilage, and spend the whole day in a reception. It was a lovely reception.
On your application form to that chambers, did you write, I'm
Yeah,
applying here
awful.
because the clerks were really lovely to me on that day when I didn't meet any of the members of
Comfy
chambers.
sofas.
So I think phase one mini pupilages were really useful. Phase two, I think their use was really just as for application purposes, because one of the things you need to show to your chambers who you're applying for is you are interested in them as a chambers. And it's very difficult to do that, but one easy way is to have at least applied to do a mini pupilage there. And if you can, to dedicate a few days there on a mini pupilage.
There was another question.
Just linked to that, do you do pro bono work, or is that an option? If you do commercial work, you can, or is that decided by your client?
I don't do any pro bono work, and I try and assuage my conscience through other ways.
I
People in my chambers do. I mean, a lot of people do.
I don't either. People in chambers do. My chambers has lots of employment law as well, and perhaps their practices lend themselves better to that kind of thing. But I don't feel so terrible about it. It's about doing what works for you, and if you can do good stuff in other ways, so be it. But the honest answer is no, I don't.
I feel wonderful now. Yeah, I do. but it's I did.
That's seriously impressive.
I did through when I was doing the bar course, BVC as it was then. Through is really great, and I would recommend, especially if they still do it, the social services side of through. Social security, sorry, because that gets you into court. It's tribunals, but it gets you in front of judges. Employment cases often settle, so it's great to learn the law, but that social security side gets in front of judges and gets some experience. So I did that phase one of my pro bono, which was for personal reasons, but now there are certain areas that within chambers there are people who take an interest, and because thankfully we're all paid fairly well, you can, if you have time in your life, to say, right, I am going to do a pro bono case. It is then difficult because you still have your commercial clients picking up the phone saying we demand this to be done, but you need to dedicate your time to pro bono case as well. So I don't do much. There's people in chambers who do a lot more, but I certainly do a bit.
We had a talk by someone from FRU earlier today, in fact, and they still do social security cases. And so if you're interested in that tip, then do go and have a look at the YouTube clip of that talk from earlier today. It's really useful.
And the employment is great because you learn employment law. They will teach you the employment law that you then have to do at bar school, which is wonderful. But just often with employment cases, they settle, so you don't get in court.
Okay, thank you. We've only got time for one more question, and this chap at the back has been putting his hand up.
I was just going to ask, how did you come to terms on what area you wanted to specialise in within commercial? And also, there's been a lot of things mentioned about what appeals to you about commercial, but I was just wondering what would be the one main thing that was kind of a unique setup of this is definitely the area that I want to go into as a barrister.
The USP is easy. It's intellectual challenge. You'll be a very lucky person if you get enough offers of pupils to choose your area of commercial law. Some people do. There are always every year the odd genius and they get an offer from 8 chambers. That wasn't me, and most people get 1 offer. And it's hard. It's really hard. So your area of commercial law will probably choose you.
And
not the other way around.
And within that, I mean, once you get to the chambers, if you're fortunate enough to get the offer and you accept and you're in, then even within that, chambers will, to a large extent, determine, at least for the first few years, the nature of your practice. Because when you're very junior, you want to get as much exposure to as much of the law that chambers has as possible. For me, at my previous chambers before Littleton, I was doing lots of insolvency law because they did lots of insolvency law. So now at Littleton, I do insolvency as part of my practice. If you'd asked me when I applied for pupilage, do you want to do insolvency law? I'd have said, what's insolvency? I've got no idea. But you learn as you go, and you take on the instructions because you want, out of intellectual curiosity, to learn about it, and it works that way. And I think most people, whether they've chosen it deliberately or not, find themselves quite satisfied with the mix of stuff that they do, because inevitably, if you do it well, you get more of it and you enjoy it.
When I was sat in your shoes, I was convinced I wanted to be a hard IP barrister. With my chemistry background, I was convinced that was where I'd end up. Now, sitting here, I could tell you for ages as to why I think financial services is great and why I chose it, but I didn't choose it. It very much chose me. As I was saying, Lehman's crashed, I decided to go to the FSA. It was all incredibly interesting. It was a wonderful life experience. So I don't think you need to stress too much about which area of law will choose you, because it's been said by everyone here, you'll end up in the position that you end up in. One thing I would say though is when applying for pupilages, you do need to look at what areas of commercial law the chambers do, and to have done your research. And I'm not saying lie and say to them that I am only wanting to do, for example, construction law, but you're going to have to know that you're going to a construction law set when you're going there for interview. I presume that's the case.
Yeah, absolutely, yeah. Don't lie, but sort of lie.
And on that note, our time's up, it's 10 past, so can we thank the panel, please?